get it. Yeah. Good morning, truth seekers out there. First Coast news on your side. We are streaming with Jacksonville. Let's make some noise. All right, guys. Good morning. How we doing? Get your waters out. Get your pens. Get your papers out. Very, very important. I mean, this is huge for all of our rights here. If you guys aren't watching, if people aren't watching this at home or listening to it, if YouTubers aren't streaming this and aren't truly talking about it in the context that it should be talked about, this is not about text messages from 2017. This is not about text messages from 2015, 16. This is not about a group of girls, ladies, that were joking around in a group chat. This is about a detective and two prosecutors, in my opinion, that violated the fuck out of Gardner's rights. I mean, bad. I think getting up on the stand and having the balls to lie. And Detective Johns is just swaying in his chair like this, like he ain't got a care in the world. Like he's protected. Like he is literally part of the prosecution team. And that guy wasn't nervous at all. He was just swaying like this, man. So good morning. Come on in. Come on in. Oh, good morning. Much needed rain finally pouring here this morning. Yeah, it probably hasn't rained here in a while either. All the grass is just like Delphi, yeah. So we'll see. But let's get so it's supposed to start at listen to this music. They're bringing it. That little background noise. That'll wake your asses up. Yay, I made a live. Hey, everyone. Hello, everyone. Hi. Where's Johnny? Johnny Lunchbucket. I just saw him. Worth every penny. Wait, what is it? No. Worth every scratch. Yeah. Scratch my back. I'll scratch yours. What else we got? Good morning, Murky. You guys, I've been waiting for this since August. So I feel like this live stream is totally for myself. I want to see what's going to happen here. I want to see what the judge is going to do. I think the judge only has one choice, and that's to give Shanna Gardner bond, put the bail at whatever. Her family has, like, she's going to be able to pay for it. I think that she should be with her kids. And if this judge comes out and says that she was not, like, that she didn't think that those years were 2022, then we got some big problems, because I don't think that she's going to say that, because I know for a fact she thought that those were 2022 bank statements. But this will be like literally when somebody gets bail in a capital case, they are facing the death penalty. Guys, this doesn't happen. This does not happen. Also, there's some decisions to be made about the discovery. So she's bringing her rulings today. This is not just like we are going to, not like we're just going to have a hearing and like nothing's going to come from this. This is actually the decision from, she said, you know what, I'm not going to write out my order or anything like that. I'm going to make my decision in person when we have to meet back here September 23rd. And this is the day. So I've been waiting for this since that last hearing. Jose Baez is on fire. His whole staff is on fire. They cannot believe what the prosecution has done. And then what Detective Johns, I think we saw it. Jose Baez is not a speechless man. Jose Baez is, he's on it. She's accused of killing her husband, right? Hired a hitman. In a roundabout way, I guess you could say that. I more like think it was her almost to be ex-husband, her latest husband. You guys, go find me a story where you tell a guy, hey, you're going to go and kill this man for me. we're going to do it like this, blah, blah, and I'm going to pay you $150,000. I'm going to give you none of it up front, and you're just going to have to trust me that I'm going to pay you this money. What? And I'm going to pay you in checks. You guys. I believe that they supplemented. So Jose was going to supplement, guaranteed he supplemented everything, and they typed it all up in a brief after that date. So do I think that Jose was clear in what he wanted? Yes, because what his right-hand man ended up doing those talking points at the end. So will Mario be in court for this hearing too? Ain't no way he's getting out. It'll be interesting. Also, they had an opportunity to bring Henry Tenen. So it was a bail hearing. This was a mini trial. They had the opportunity to call anybody they wanted the state. And so Henry Tenen is set to allegedly testify against, everybody. Even though Henry Tenen cannot possibly testify that he ever met Shanna Gardner, ever talked to her, ever, there is 0 links. So they had the opportunity, the state had the opportunity to bring him in and have him testify at that bail hearing. And instead they said, we're just going to have the Detective Johns lie and the prosecutors mislead the tribunal and having
any
here we go.
Discovery issues that
Wait, what's going on? Are they just what's going on here? Come on, man. Don't fuck around with me.
It's almost like a cumulative error argument. Like all of these things amount to this.
Okay.
So in the form, this court did the analysis on the grounds raised by the defendant, and also viewing the defendant's motion related to the different areas, the remedies. I've addressed each one of those. So I'm going to deny it, but it's without prejudice because obviously discovery is ongoing, and I don't want the defense to be under the impression that you can't bring this to the court's attention, or if it remains that I would then readdress it. Does that make sense?
It does. And I'm understanding the court's position. So if some new information comes about, we could refile this particular motion, not just asking for limine, but this particular motion since it's denied without prejudice.
Correct.
Yes. So I think that the request for a jury instruction, that's not ripe yet. Or I have to analyze that under a different standard. Additionally, the request and the argument by Mr. Bias at the last court date to release her on bond, I don't believe this is the proper motion or vehicle in order for this court to review that. I've reviewed it based on the papers, reviewed it based on the Richardson analysis. And if you believe these things to, just like the rule says, 3.220 in, if there are things that remain, and I know the defense has brought several issues to the court's attention. Mr. Bias argued for a really long time, cumulative. At this point, I've analyzed it related to the issues brought to the court's attention. And I don't believe that there's a discovery violation. That's what I found. However, if these things remain, if it continues, I want the defense to understand the court's ruling. You can bring it to my attention again, okay?
And not to belabor the point, because I didn't ask this specifically, is the defense permitted to refile or renew the request for an archer?
Yes, you can do whatever you feel as though is appropriate. I've addressed what you brought to my attention, is what I'm saying to you. You understand? Like the discovery violations, there was, in my view, Mr. Bias was arguing the discovery violation / something that was not before the court. Does that make sense? Misleading the court.
I don't agree, but I do understand the court's position.
Okay.
Yes.
Good. I don't agree, but I understand what you're trying to say.
Without prejudice.
Yeah. To save her ass. There you go, London. You ain't no dummy.
Motion then would be motion to compel
What's the state's position on that?
Is this the motion to compel subpoenas?
Yes.
I'm in agreement with providing discovery if it exists. I've spoken to my detective and am in the process of speaking with ATF. I believe that there was only one subpoena served, the one from Ms. Lucetti, which they're in possession of. At this point, I don't believe there are other subpoenas served, but I don't know that for sure yet. And if I find out otherwise, I will provide those to defense counsel. So I'll fulfill it if I can. If that discovery exists, I will provide it.
When will you know?
I'm supposed to have a call with ATF today. I spoke with Jacksonville Beach Police Department last week.
Okay.
What have you been doing since then?
All right. So
No, no,
I'll
no.
grant that by stipulation.
Yes, granted. There's a win for the defense.
What about the motion for the transcript of
Ooh.
Detective John's?
The state's objecting to the motion.
Ooh.
I provided counsel with case law, and I have some for the court as well. May I approach?
Yes.
Okay, let's see what they're asking for here. They want transcripts. What are they talking about? Woo! Defense winning it. Sure, Stifler. Take a big stiffy,
In order to
Stifler.
review the cases, they basically state for the long-standing tradition of grand jury proceedings in our country
Ooh.
are meant to be secret to ensure the integrity of the justice system.
Fuck
In
no,
both
unseal 'em.
cases, Brookings versus State, 495 Southern 2nd, 135, which is the Supreme Court of Florida. The court does the analysis, and this is on
This is gonna get.
page-
Defense is gonna win this one. They're trying to keep Detective Johns's
3 of the
grand
opinion.
jury testimony.
There is no pretrial right to inspect grand jury testimony, while holding an in-camera inspection of such testimony is within the discretion of the trial court.
There we go.
The court discusses their decision in Gent, J-E-N-T, which is a cited case, that a mere surmise or speculation regarding possible inconsistencies in testimony is not enough to require the production of grand jury testimony. They discuss the importance of maintaining the secrecy of grand jury proceedings, and that the parties seeking the disclosure must make a strong showing of a particularized need in order to outweigh the public interest in secrecy. The other case, the state cited Bing versus State, 323 Southern 3rd, 830. In this case, the first DCA considered a request to unseal grand jury testimony, but denied it, finding that numerous alleged inconsistencies among state witnesses were an insufficient grounds to grant the motion, where defense is able during cross-examination to direct jury's attention to any purported inconsistencies between the witnesses. And also it analyzes a request to unseal grand jury transcript in order to determine whether the indictment was maintained upon perjured testimony. In this case, the court found that mere allegations of inconsistencies failed to provide a specific basis to conclude that a grand jury witness committed perjury, and the appellant could not seek a blanket production of grand jury transcripts based on mere surmise or speculation regarding possible inconsistencies. And that even when the state's case at trial differs materially from the grand jury indictment, there's no error in the trial court's refusal to dismiss the indictment. Court finds due process is implicated only when a prosecutor permits a defendant to be tried upon an indictment which he or she knows is based on perjured material testimony without informing the court opposing counsel in the grand jury.
Come on, baby, you got this.
Motion to unseal is merely speculative. It contains surmised allegations. There has been no particularized strong showing by defense that there has been any material perjury or any perjury whatsoever in the grand jury testimony of Detective Johns regarding the indictment. And for the reasons outlined in these cases, the state's going to object.
Okay, let's go, baby. What you
So,
got?
Your Honor, if I may.
Yes.
So in response, Your Honor, looking at that first case, it's mere speculation that the state is claiming, first and second case, and that is not what we have before the court. We have a specific instance or instances of the lead detective before this particular court making false and misleading statements of material matters to this court.
In an Arthur hearing.
So now we are asking, based on what we know to be false representations of Detective Johns, for his testimony before the grand jury. Because if he's made those false statements to the grand jury, then we are moving forward on an indictment based on perjured testimony. The
Yeah!
only way we can verify that, Your Honor,
Is
to
if get the
actually
grand
have
jury.
the
We
grand
need-
jury testimony.
Duh.
But what exactly are these false statements? The court's aware that they received, that the state made a representation to Detective Johns about 3 checks. The checks initiated, or the funds allegedly initiated from the trust of Shanna Gardner. What the state did not argue or present clearly to the court as part of this misrepresentation is that the trust funds that they presented were from 2021. The checks to Tenon were in 2022, but it doesn't stop there. The funds that they showed from 2021, the balance on that very same check resulted in $1,900 and I believe it was about 25 cents. The check to Tenon was for $5,000. So again, clearly the funds that they're showing coming from Shanna Gardner's trust fund weren't related to the check that was provided to Tenon. The theory of the state's case is a murder for hire. The funds that they're showing aren't related.
Exactly.
That's material.
100%.
They also made a representation to the court of a truck that was driven by Tenon, and an allegation that only the individuals involved with the murder for hire would know about this truck.
Yes.
Why
yes.
is that a problem?
Yes.
Because they failed to demonstrate to the court or show to the court that the roommate, Ordway, was well aware of the connection based on testimony or based on an interview by law enforcement. So these aren't minor or insignificant issues.
They are
These are
not.
material misrepresentations.
100.
Whether it's the truck, whether it's the fund, but it doesn't stop there. And again, this is all through Detective John's representations to the court. There's the text messages that Detective Johns was well aware was based on a joke from some 20 years prior. And what did the state present to the court? Text messages, absent the context that this was a very old joke, absent the context that there was a text marked LOL.
And he didn't put it in.
To say that this is mere speculation when we can point to verified instances of misrepresentations by Detective Johns before this court, and knowing that he is the main witness, or at least it appears he's the main witness before the grand jury, his testimony has been perjured
Yes.
as we stand here before this court. So that's why we're trying to get through and get the actual
She
testimony
has
before
to
the
give
grand jury.
them his
Because
testimony.
if the case should proceed with this perjured testimony, Shanna Gardner's due process rights
Have
are
been
in jeopardy.
violated. Yep.
We are trying to have a fair trial and a fair opportunity for
She's so
Shanna
good.
Gardner's case.
Slow.
So this isn't a fishing expedition. We're not asking for every witness that testified before the grand jury. We've
One.
narrowed it down to specifically Detective Johns based on his material misrepresentations to this court already. And it's a fair connection to say that he's made similar, or if not greater, misrepresentations to the grand jury. And the only way we're going to know that for sure is to actually get that grand jury testimony of Detective Johns.
Yep.
So for that reason, Your Honor, and based on all the argument that's before the court in
Yes.
this written motion, we're asking
Come
for
on.
the court to unseal Detective John's testimony, not for a fishing expedition, but to verify that this indictment that we're all before this court on is actually valid
Yes.
and not based on perjured testimony.
Can I just ask a practical question to the state? Why did you agree on other witnesses and you're not agreeing on this one?
Because I was fulfilling my Brady obligation, knowing that Ms. Jensen had withheld or given inconsistent testimony at another
Ooh.
time. I have no such misgivings about Detective Johnson.
Oh, bullshit.
So you're saying to me that you've reviewed the testimony, the grand jury testimony, and these areas that the defense is pointing out, these 3 areas, there is no Brady in the state's view.
Not have Detective John's grand jury testimony because it's sealed. I obviously was present for it and have my notes from our pretrial and from the actual presentation.
Fuck her up, London.
Which was very
Fuck her up.
significantly similar to the sworn affidavit he gave on the
No.
Title III
Get her,
wiretap
girl.
affidavit, which they have possession of.
Nope.
I
Get
can't
her.
recall specifically these issues. I don't
Yeah.
believe
Listen to
there
her
was
fumbling.
much discussion
Yeah.
of
Now your ass is on the line.
some of these, but I can't say for sure. I haven't reviewed.
What a
the
great
transcript.
question.
But what I would say is they're talking about testimony that came out at a bond hearing regarding the detective's testimony on hearsay. So he's saying what other witnesses have said. We haven't deposed these witnesses. We haven't deposed Detective Johns. They haven't even asked him what he testified to at grand jury, or they haven't even asked him directly about these issues, vetted these out through discovery. So I think at this point, they're saying what they perceive to be misrepresentations, which I disagree with. I think the two parties can look at evidence differently, have different theories of a case and different theories of evidence. That's why we have a justice system and trials.
Oh, Stiffer's getting
They're
stiffy.
saying that they believe Detective John's testimony is inconsistent with their theory of the case, and therefore there must be or potentially would be other misrepresentations in his grand jury testimony.
Why are you objecting
That's a
then? If
speculative
you think that
statement
he's
without
on the up and up, who
specific,
cares?
Substantive or particularized merit from the.
If you think he's on the up and up, why is it why is it a problem?
You're on.
I think secondarily, if the court were to be inclined to consider granting the motion, the state would request that Your Honor do an in-camera review of the transcripts before releasing to either side. And if Your Honor perceives there to be anything that needs released, that those particular sections can be released.
No.
I'm going to go back to my original question. So on Jensen,
There we go.
did you have the same information? That is your notes, and you made that analysis and agreed.
God,
with the
she's so
defense
good.
to,
She just.
release it.
So when Ms. Jensen testified at grand jury,
I'm gonna go back to my original
she
question.
was reluctant to be truthful. She gave some statements, and then at a secondary meeting at the state attorney's office, she gave additional statements. So I believe that to be information that should have been brought to the attention of defense counsel, which is what I did. I had a phone conversation with Mr. Carodi. I told him that Ms. Jensen continued to withhold and continued to minimize her involvement, in my estimation, and that she had given us additional statements at a meeting subsequent to grand jury that she did not disclose at grand jury. And I believed that meant, while it was not necessarily Brady because it did not tend to exculpate the defendant, that the fact that a witness gave additional statements that she did not disclose under oath, I believed that they should move to unseal the grand jury testimony. I told them so. It's in the email that Mr. Carodi that we entered at the last hearing. It's in their motion to unseal, and I had no objection.
We need to
In
take the
this
Jones.
case, their motion has presented nothing to the state that leads me to believe there's anything that they're entitled to receive that is.
This is, Ms. People, do you want to be heard? I think what I'd like to do is before,
She's gonna
I'd
unseal
like
it.
to read these cases, and I would ask that the state look at whatever testimony, make an analysis of what you believe, and I will take it up again. So,
If I may, Your Honor, just
Sure.
a brief point, just making that distinction in the second case, Bing versus State, 323 Southern 3rd, 830. And this particular case ends with because the defense conceded. There is no concession from the defense on this particular case or the material facts that we're arguing in this particular
Good job.
case. So I bring the court's attention to the distinction between the cases brought before the court,
okay.
where we have the perjury and we're not conceding to the information that,
Do you have any cases you want me to read?
other than what's cited in the,
Okay.
the motion, no, Your Honor.
I'll take this under advisement.
She's gonna unseal it.
I mean, maybe on a review, the state will change its position. If not, then I'll make the ruling. Okay.
Oh, there we go.
But I'm going to take this one under advisement.
There you
I
go.
printed the other one.
If the state doesn't want to change.
Motion to compel the subpoenas. I'm going to grant that by stipulation.
Yeah.
What else is left for today from the party's perspective?
I believe that's all for the Gardner case, Your Honor.
Okay, Mr. Dreiser, do you have any? I have some things I want to cover.
Oh, okay. Oh, now here's Mario's attorney.
The only update that I have is there was issue about deposing the children at the last court date. We have done that. Those depositions are done. So I
Oh,
just wanted to report that we were able to work all those issues out and get those depositions accomplished.
That's great.
That's
Uh,
great. Shouldn't have been that
We
difficult.
have depot dates going back and forth for many different witnesses in different state, civilian, and federal witnesses. And I think we're working through the remainder of the discovery issues. And at this moment, I don't see any court intervention being necessary.
They were expecting
Okay.
plea deals.
When are the depot dates?
We were kind of going back and forth on which witnesses this morning, but they're going to get set. There'll be witness.
I know. What are the dates though?
I don't have like the specific dates. We talked about October dates and November dates and December dates and whether we would do the federal witnesses in December. But if you thought that I was saying that I had dates, I just had the concept that we're going to continue depots each month moving forward.
On the federal witnesses, are they requiring a 2E request?
They are, and I discussed that with Ms. Stifler this morning, and she thinks this particular witness that we would like to depose the state will prepare the 2E letter and get it to him, and it should not be an issue.
All right.
It's the cast agent, Agent Blythe, and he testifies for our office all the time. We just email him a 2E letter from our office, and
And I would
it's
be,
very flexible.
if you need this, I'd be certainly, I would email you the depot dates that we select.
I would like those.
Sure.
When do the parties foresee this case being ready for trial?
Yes, we're gonna talk about trial.
This morning for the first time, like the idea of getting a trial on the calendar was discussed. The only hesitancy that the defense from Mr. Fernandez's perspective has is we don't have all of the discovery ironed out at the moment. There's discovery, I think, that's still being processed through the secondary taint issue from the first issues we've had. It seems as if there's some ongoing discovery. I think Ms. Stifler mentioned this morning that she was either about to release new civilian or seen witnesses or just recently did so. I will admit that I wasn't sure which one, but in my mind, the discovery is still sort of ongoing. Setting a trial of this magnitude seems premature, but the state had floated with no discussion with the defense agreeing, but August of next year. And I asked how long they envisioned the trial, and about a month is what I heard, a week of jury selection. I think they were saying probably 2 weeks for their case in chief, and I think they threw in an extra week not knowing what the defense would call and who we would call. So I think that was a really generalized conversation. I'm not.
All right. We need a trial date. Okay. I know that you may think that it's premature. I think it's it allows the parties to operate with some type of certainty, and it allows, with a case like this, it allows the court to make proper preparations. Additionally, on the capital side of this case, I know that you all are still working through the issues related to maybe guilt. A couple of things have come to my mind that, like, we need to, if you're going to file whatever capital litigation motions, I want those filed by the end of the year. I want to be able to work through some of those things, know where you all have objections, at least by the end of the year. So, yes, Ms. Peoples.
If I may, I would just ask if we could readdress this at the next setting. I know the Gardner team, we've got different schedules or different calendars to deal
Right.
with.
No, I'm
we
I'm
could-
not meaning to stress you out. Okay. I see the stress on your face. I'm bringing it up because it's
Okay.
never been brought up before.
Fair.
And I like goals. I like deadlines. So
So if we
I'm
could-
putting it out there for you all, and however many lawyers need to get their schedules together. I know with lawyers, especially y'all, I need to book early and often, and that's what I'm going to do.
So
Okay.
could we do that booking, or could we even have the parties present suggested dates or suggested
Yes,
deadlines
and we're not going to go too far in the future either. We're going to go like 2 weeks from now.
for next
Yo.
month? Or could-
No, I'm talking like in a couple weeks. We are going to iron this out.
Dates, okay.
Yes, I want you all to be feverishly that's why I'm putting it out there. Okay, I'm not setting anything today.
Yes, good
I'm setting another
woman.
court date,
Hell yeah.
right? So Miss Peoples, do not stress out. Okay. I want the state, okay, to
Just
take a
look at your
realistic
calendar,
look
man.
at how you believe this case, how much evidence you're going to put on.
Lawyers don't know how to
I'm
plan for
gonna- and
dick.
I'm going to
Good job.
block y'all off.
Block
And
it.
it's going to be a while from now.
Yeah.
Additionally, I'm putting these things out there. I want to know when you all believe that you can have your capital litigation prepared in order to submit to the court. Okay. I want to know from the state's perspective how long you believe this case needs to be tried. The question in my mind is logistics. Okay. Is there going to be an ask for sequestration? I need y'all to start talking about these things.
How about a
okay?
change of venue?
And then additionally,
Get it out of Jacksonville.
when we get the jury selection date, realistically, with the
I-
logistics,
I'd want her as
and
my
the
judge,
number
though.
of lawyers, how long y'all believe jury selection will take, if you want to utilize, how many jurors, things like that. I need y'all to start talking about those things.
Yeah.
And we are. I know that you all have been focusing on the guilt phase, but we need to start thinking and setting court dates that are going to take up a lot of time, a lot of resources.
Yep.
So
Capital
I cannot have
cases.
this kind of just floating out, and we need to start being. We're rounding in my mind, maybe halfway point to, 3/4 of guilt. Mr. Dreiser, you're looking at me funny. I think that y'all can do it. Okay. And then y'all can set your deposit. That date should start informing how many depots, block setting, whatever y'all have to do to try to accomplish these things. Okay. And I need to get some type of gauge on where the defense is with any type of mitigation, if you need any intervention on the court. Okay.
Some information from you that I would request, and some information, if I may. I am out from the 4th to the 14th of October. We're going to take that into consideration for the next court date. Not that I have to be here, I guess Mr. Hill, Mr. Gisoni was being handle it. So I just wanted to let you know that.
No, I'm talking like September 3rd, like next week.
It may be productive for the state and all of us to discuss these things together to bring, hopefully some consensus to the court. Suppose it was a month, and suppose it was.
What was a month?
The trial, the whole, suppose that's an accurate time frame, we all agree.
For what, just his case?
Do you have any insight for us as to at the end of next year when you may have a month, so we're not?
I'm not booked out that far. And then this is a priority case, obviously. And so I will make
Yes.
whatever arrangements. That's why
Exactly.
I need y'all to get together.
This
And
is a
doesn't
priority
need to
case.
Just be something unsaid. So I'm saying it. I want you all to get together,
Mhm.
and then I'm going to set, and then we're going to work towards it. And I'm going to give you all whatever time you need so that we can get to it. Okay. But I'm not booked out when y'all are setting or saying. I'm not booked out that far. So I can give you all the time that you need. And if I will avoid it, I'll avoid the a week or two prior to setting days aside if y'all want me to do that.
Yeah. If y'all would work
But we
together,
need to
she
start
wouldn't have to just
looking at
pick the
that.
dates.
Okay.
Like, these lawyers are
That's
too
what I wanted to do.
pompous. Like, who do you
Anything
think you
else?
are?
No, Your Honor.
With defense counsel.
Okay.
God.
All right. I'll see y'all next week.
Yeah. We'll see you
Have a good
next
day.
week, baby.
I can do
Woohoo.
Monday. That's exactly a week. Do you want that? Or I can go in a little bit further in the week if y'all want more time. That's fine.
Whatever you guys want.
Wednesday,
Sorry.
sorry, I didn't hear.
I'm sorry.
I'm sorry, I didn't hear that you said Monday. I know you said next week generic, but it's like.
No, next week.
If she,
Miss Peoples and her folks do Wednesday.
Peoples is good. So let's see.
No,
No, it's.
Oh, it's not coming up.
Later. Sorry.
This is great. I told you guys are gonna love this judge. She's gonna grant that they're getting the.
Should be fine, Your Honor. I can't.
if you need a minute, I can set it when you're ready.
It's I know what it's like in those damn rooms. You can never get service. Your Wi-Fi goes.
Mr. Jackson, give her a second. All right.
So we're looking at October 2nd.
Good morning, everybody.
Sorry, October 3rd, Your Honor?
September, next week, Miss Peoples. It's the 30th, the 1st, or the 2nd.
Someone will be there.
Well, I don't want to set something when you all don't have the time. Wednesday?
Yes, Your Honor.
Okay, Wednesday.
All right, that's October 2nd. See you all then.
Okay.
Thank you. 9 a.m. pretrial. Here are these orders.
Is that going to be in here, of course?
I don't know.
Oh, there's Mario.
8:30, okay? Are y'all okay with that? I'll set it at 8:30.
Okay. 8:30, guys. That's what happened. They need to be on it. You hear that, Jacksonville? Okay, we didn't get to hear the beginning of this shit because they started late. There's Shanna Gardner right there. She was there. It's interesting the court angle that they're doing this. What's going on? I wonder if somebody said that they didn't want a certain angle. They moved the camera over here.
Thank you, Freeman.
Yeah, no problem.
Oh, we have a hot mic. We have a hot mic on. Hang around. You never know what Judge Kite might say. She might say, these damn fools. There's Judge Ito's brother right there. He just walked in front of the camera. I'm going to have a field day with that for this trial. If he makes it. Oh, there you go.
They treat me well.
Oh, see, hot mic. Leave it go. Leave it on.
Well,
This is how people lose privileges. Cut it, Jacksonville. Cut it. Oh hell yeah. I'm riding all the way with this one. This is gonna be theatrical. Detective Johns is in some hot water, man. I would not want to be him.
about yourself.
Look at this guy. Miss Peoples, we love you over here. TNT. Woo! She was so clear and concise. Kite brought it to Stifler this morning. And I'll explain why. There's Maserati. I'm just going to call him Maserati from now on. Look at Jacksonville. Oh my. You guys, this is her courtroom, so like she has another case after this. So what are they doing? Yeah, freckled Gemini. I don't think she plays either.
Are y'all loading the chute?
Oh, good.
Okay. I need the state to load up the chute, please.
Okay, what's going on? What are they doing? What is Jacksonville doing? This is the next hearing. This is hilarious to me. There he is, Ito's brother. You guys look at Ito's brother's the bailiff. I'm sorry. Lana, stop being so silly. You guys, everybody else is going to be covering this case, like, is so anti Shanna Gardner and Jose Baez. It's not even funny. We will, that is not how this will be handled over here. All right, guys, they went ahead and cut it. All right, so let's talk about it. And we're going to talk about it by, I just want to rewind something here to see if they will allow this to be, yeah, right here. So Jacksonville, someone was sleeping at the helm.
But it's without prejudice because obviously discovery is
Okay, so look at this. Bunch of idiots right here.
discovery issues that
Look at them. What a bunch of morons.
it's almost like a cumulative error argument. Like all of these things amount to this. So in the form, this court did the analysis on the grounds.
Okay, so basically what happened at the last hearing is it was for discovery violation. So she could only rule on what the hearing was supposed to be for. So discovery, right? But then she makes it perfectly clear that the discovery issue is it's being denied without prejudice, okay, because discovery is ongoing. But basically alludes to the fact that if this continues, I want to know about it and you need to file. Okay. And so, but then she says, so can we refile? We want another bail hearing. And so that's what's going to happen. They're going to be filing, okay, for another Arthur hearing. All right. That's how that gets handled. And that's why she wasn't ruling on, it wasn't up for discussion on if Detective Johns committed perjury or not. Based on everything that you say under oath, it can be used against you whenever, wherever. And they're going to refile for a bail hearing. And so I believe that there's going to be another bail hearing. But the best part about this whole thing is Judge Kite says, because the defense is asking for the grand jury testimony, the transcripts to be unsealed, but only for Johns. And whereas like in Brian Colbert's case, remember they had to do the same thing, and he unsealed, Judge unsealed all of it. And here, that's what's going to happen. Detective Johns's transcripts are going to be unsealed. I promise you that's happening. She more or less said it. She said that if the state doesn't want to change their position, because she had a question, she's like, why are you okay with everybody else's testimony being unsealed, but you're not okay with his? She's like, let me ask you a practical question here. Why are you not okay with his not being? And that's just like
Testimony. There.
Where is she?
So now we are asking based on what we know to be false representations of Detective John.
Okay. So they're saying we are providing you with the information so that you can unseal it. We know Detective Johns just stood up here at that Arthur hearing and lied his fucking fat ass off. You saw it. We saw it, right? This is giving us grounds now. We want to see what he testified to the grand jury, because if he committed perjury there, the indictment is gone. Everything they were trying to do in the Brian Colbert case, we're fighting this grand jury indictment because what the grand jury was told was evidence that's inadmissible. Like there's 24 things that they raised. Jose Baez, the only way that you can see what the grand jury indicted somebody on is to see the testimony. And then this woman acts like Stifler, ADA over there. She just got herself just twisted up, man. I can't even believe, like, you guys, they are riding and dying with this.
For his testimony before the grand jury. Because if he's made those false statements to the grand jury, then we are moving forward on an indictment based on perjured testimony. The only way we can verify that, Your Honor, is to actually have the grand jury testimony. But what exactly are these false statements?
You guys get it? So we need his grand jury testimony. I promise you, in in that testimony, they did the same exact thing. Okay. When it comes down to this paper trail, okay, they testify the same exact way. I can only imagine what this man has said, but the state wasn't stipulating to that it happened. They were objecting to Detective Johns's transcripts, but nobody else's transcripts. If you want to get another witnesses, go right ahead. And that's what London asks her is, well, why are you okay with all the other witnesses' trial transcripts being looked at, but not his? Okay.
The court's aware that that the state made a representation to Detective Johns about 3 checks. The checks initiated or the Gardner's case. So this isn't a fishing expedition. We're not asking for every witness that testified before the grand jury. We've narrowed it down to specifically Detective Johns based on his material misrepresentations to this court already. And it's a fair connection to say that he's made similar or if not greater misrepresentations to the grand jury. And the only way we're going to know that for sure is to actually get that grand jury testimony of Detective Johns. So for that reason, Your Honor, and based on all the argument that's before the court in this written motion, we're asking for the court to unseal Detective John's testimony, not for a fishing expedition, but to verify that this indictment that we're all before this court on is actually valid and not based on perjured testimony.
Can I just ask a practical question?
Like this is why she's great. Can I just ask a practical question to the state? Ready?
To the state, why did you agree on other witnesses and you're not agreeing on this one?
Because I was fulfilling my Brady obligation, knowing that Ms. Jensen had withheld or given inconsistent testimony at another time. I have no such misgivings about Detective John's testimony.
So you're saying to me that you've reviewed the testimony, the grand jury testimony, and these areas that the defense is pointing out, these 3 areas, there is no Brady in the state's view.
Not have Detective John's grand jury testimony because it's sealed. I obviously was present for it and have my notes from our retrial and from the actual presentation of testimony, which was very significant.
She was at the grand jury, okay? And so basically this judge flat out asks her, like, so you don't believe that he could have, like, you should be saying right there, her saying what she's about to say here literally ropes her. She's standing by the fact that there is no reason to have, like, he didn't do anything wrong. He didn't testify to anything that's not true.
Significantly similar to the sworn affidavit he gave on the Title III wiretap affidavit, which they have possession of.
Remember, this is a guy that served an out-of-state subpoena, but didn't serve an out-of-state subpoena. He served an in-state subpoena. He has no fucking clue what he's doing. He has never worked a homicide in his life. This is his first homicide case. It's a capital case, and you put this man on as your lead. Unbelievable. With the amount of, like, who does Jacksonville think that they are? Oh, they think they're Moscow, Idaho. This is just wild.
Can't recall specifically these issues. I don't believe there was much discussion of some of these, but I can't say for sure. I haven't reviewed the transcript. But what I would say is they're talking about testimony that came out at a bond hearing regarding the detective's testimony on hearsay. So he's saying
it's not on hearsay. Those checks, you lying bitch, aren't fucking hearsay. Y'all put that shit in there. Unbelievable. This woman is sick. This woman is a bitch of a prosecutor. Okay, this would be the person that's, oh, I see some marijuana out here, slaps ya. Like, Max. Girl, get laid. Ridiculous right here. Liar. You're a liar. Anybody that dates this broad, she lies to you every single time she's talking. All right? I'd use it for one thing and one thing only.
saying what other witnesses have said. We haven't deposed these witnesses. We haven't deposed Detective Johns. They haven't even asked him what he testified to at grand jury, or they haven't even asked him directly about these issues, vetted these out through discovery.
What does it have
So
anything
I
to do with
think at this
anything?
point, they're saying what they perceive to be misrepresentations, which I disagree with. I think the two parties can look at evidence differently, have different theories of a case and different theories of evidence. That's why we have a justice system and trials. They're saying that they believe Detective John's testimony is inconsistent with their theory of the case, and therefore there must be or potentially would be other.
That's not what they're saying at all. And if Judge, and she's not going to let her, she's not going to get real. She is not going to get fooled by this woman's word salad. Okay. By this woman's, I'm sorry, unethical bullshit. She's not going to put up with it. I'm telling you that right now. Because these are lies. If you've been following this case, what this woman is saying right here is absolutely 100% a lie.
Misrepresentations in his grand jury testimony. That's a speculative statement without any specific substantive or particularized.
Jose
narrative.
Baez, you better go at this motherfucking broad.
Correct. From the state's perspective.
I will be in Jacksonville. I want to see this woman in
I think
person.
secondarily, if the court were to be inclined to consider granting the motion, the state would request that Your Honor do an in-camera review of the transcripts before releasing to either side. And if Your Honor perceives there to be anything that needs released, that those particular sections can be released.
I'm going to go back to my original question.
Like, B, you didn't answer none of my question. I love it. I'm going to go back to my original question because that's her way of saying you just went on some tangent, okay, that has nothing to do with what the hell I'm talking about here.
So on Jensen, did you have the same information that is your notes, and you made that analysis and agreed with the defense to
Yes, ma'am.
release it?
So when Ms. Jensen testified at grand jury, she was reluctant to be truthful. She gave some statements, and then at a secondary meeting at the state attorney's office, she gave additional statements. So I believe that to be information that should have been brought to the attention of defense counsel, which is what I did. I had a phone conversation with Mr. Carodi. I told him that Ms. Jensen continued to withhold and continued to minimize her involvement, in my estimation, and that she had given us additional statements at a meeting subsequent to grand jury that she did not disclose at grand jury. And I believed that meant, while it was not necessarily Brady because it did not tend to exculpate the defendant, but the fact that a witness gave.
Why didn't you just record that meeting, ADA Stifler? Oh, that's right. Because you threatened the living fuck out of Jensen. Okay. That's why you couldn't record that meeting. Because you violated her rights. You are a sick woman. It's all going to come out. And I feel really bad that Jared Bridegan has you defending his case. Okay. Because this is not how you do it. You don't lie.
Additional statements that she did not disclose under oath. I believed that they should move to unseal the grand jury testimony. I told them so. It's in the email that Mr. Carodi that we entered at the last hearing. It's in their motion to unseal, and I had no objection. But in this case, their motion has presented nothing to the state that leads me to believe there's anything that they're entitled to receive of it.
This is, Ms. Peoples, do you want to be heard? I think what I'd like to do is before,
She's going to give them.
I'd like to read these cases.
Before I just go ahead and give them,
and
I'm going to
I would
read
ask
these,
the
but
state look at whatever testimony, make an analysis of what you believe, and I will take it up again. So.
I mean, Your Honor, just
Sure.
a brief point, just making that distinction in the second case, Bing versus State, 323 Southern 3rd.
this sealed it.
830. And this particular case ends with because the defense conceded. There is no concession from the defense on this particular case or the material facts that we're arguing in this particular case. So I bring the court's attention to the distinction between the cases brought before the court,
Okay.
where we have the perjury and we're not conceding to the information that.
Do you have any cases you want me to read?
Other than what's cited in the
Okay.
the motion, no, Your Honor.
I'll take this under advisement.
Here it comes.
I mean, maybe on a review, the state will change its position. If not, then I'll make the ruling. Okay.
You guys hear
I'm
that
gonna take
part?
This one under advisement. I've granted the other one.
Right there. If they don't change their position.
Any cases you want me to read?
Right
Other
here.
than what's cited in the
Okay.
the motion. No, Your Honor.
I'm gonna, I'll take this under advisement. I mean, maybe on a review, the state will change its position. If not, then I'll make the ruling.
There it is. There it is. Maybe like that was like to let ADA Stifler know you might just want to stipulate to this. Otherwise, it's going to come out that my ruling is siding with the defense, defense. If that wasn't a foreshadowing of what's about to happen, they're going to get those records because, and they're going to file for another bail hearing. And either way, Johns is in serious shit. You guys understand that this is all going to be known to the jurors. It's kind of going to be like a little Karen Reed with the whole, like, your lead detective being shady as fuck. I could go on and on about this case, but I really just wanted to stick to what this topic was. And I believe that there's going to be another bail hearing. I believe that those transcripts are going to be unsealed, and we're going to be back at it, next, the second, the third, because Judge Kite's going to make sure that, hey, we're running a tight ship here. We're going to lay down this. And now I'm curious, when they're talking about like this trial date, are they going to keep it that there are Shanna Gardner and Mario Saldana going to be tried as co-defendants? Because when this originally came out, Jose Baez was trying to separate the two. So I wonder if that has changed as far as strategy goes. Just so you guys know, Mario Saldana has a public defender. Okay. I'm going to look into seeing, a little bit more about him. There is no gag on this case. So maybe I can, get in touch with the public defender's office, and he's got to have a help with this case. But talk to some of those peoples over there. I've reached out to Jose Baez's team. Actually, I think I talked to peoples over here. Like I said, I think that, but I'm curious about when they say this is only going to be like a month trial. That's interesting to me. And it's going to be really interesting. Remember, we have Henry Tenen that is set to testify against Saldana for sure. I don't know how he's going to be able to possibly implicate. I cannot wait till he talks about this payment, though. Yo, Ben, yeah, I killed somebody. I ain't getting no money. And they just told me they'd hit me on the back end. You guys, I've never heard such a thing in my life. All right. Never in my life have I ever heard. I mean, people get paid to, like, beat people up ahead of time. You want me to kill somebody? Like, what? No money up front? Come on now. So I'm interested to hear what Henry Tenen has to say when he's on. Remember, he took a deal and it was like, here, you're going to do 15 years. And then I want to know if is it going to be an automatic minimum of 15, or would he get out in 7 to 8 for good behavior? So I'm just very, very interested to see what, how this plays out. And I think mainstream media needs to cut it out. You got prosecutors and detectives violating our rights, and y'all want to talk about text messages from 2016 and 17. The media is supposed to be providing us, the people, with and pointing out things, and instead they're covering for the prosecutors here. So you can't even get a burger without paying first, right? Checks in the mail. Is there a link? No, man. No. I think Henry is innocent. Yeah. Henry could have been like, he's not the shooter, but say you're the shooter, and so we can get everybody else. because you'd be doing this amount of time anyways, because you're involved in the conspiracy. You gave up your truck to be used, all these things. Well, if you just say that you're the shooter, we'll give you 15 and you'll be out 7 or 8. I mean, dude, I am not putting anything past an ADA that wants to get up there and lie, okay, and a lead detective that wants to get up there and lie. And that's what's going to put their whole case in jeopardy when you present that to the jury, if this jury, is worth a damn. But you gotta get the right people on the jury, because this is wild. I believe that Mario Saldana is involved. I don't think that Shanna Gardner is involved. I think that Mario did this to try to keep and stay connected to Shanna Gardner and get paid for the rest of his life and have that cush life. He did it to try to save his marriage, and because Shanna Gardner was, if they get divorced, he's out of the gravy train. You know what I mean? So just think about that. All right, guys. Thank you so much for joining us. You guys are awesome. And thank you, moderators. Oh, I'll be dropping a new Brian Drake pre-record. And then I don't know. I think JLR is still over there in Springfield. If he's still there this morning, I'm gonna jump in my car and I'm heading to Springfield, just so I can beat my horn and be like, JLR! Hi, JLR! It's Lana! JLR! JLR, put me on film, baby! And then I'm just gonna pop the top and flash him. Woo, JLR! I signed a JLR, my titties! Would you guys just lose it? This is how you guys wake up in the morning. Happy as a clam. I'm going to go over there and fangirl JLR. Magnolia, you can join too, baby. I love you. Mwah. He isn't. He better not be storm chasing. He better be over there in Springfield. I got to go check it out. But I want to be, I got a couple days here so I can be boots on the ground. And I want to be boots on the ground. So, all right, guys. I will, I'll see you on the flip side. Be safe. Till next time. Over and out. Oh, I got to make an out. I'm going to make an outro. Yeah, outro. Is that what it's called? I think I'm going to make one of those. Yeah. I'm going to pop the top. You guys like that? Pop the top for JLR? JLR is over there at breakfast and I'm driving by, popping the top. Woo! He's going to be like, oh my God, the Haitians. Oh my God, Lana! All right, guys, be safe. Oh, yeah, I think Annie Potts is talking about something at noon. Something Idaho 4 related. I'm sure of it. She wants to dig into. I told her she can read to me, and I'll just soothe my way. Miss Potts.